Good day to you. This Paddocks tutorial is designed for owners, executives and managing agents of all types of community scheme, and it deals with the Municipal Property Rates Amendment Bill. I'm going to give you a quick overview as usual. What is this new bill? What is it designed to achieve? The apparent unintended consequence, what would this mean, and what could you do about it? What is the bill? Well, it's proposed legislation, a proposal by the Department of Cooperative Governance to amend the existing statute, which of course deals with municipal property rates. It's been published for public comment, and you can download it and read the full thing from the address that I give you on the screen now. What is it designed to achieve? Its stated object is to address the problems that have been experienced in the implementation of that Act over the past 5 years and to promote the effective and efficient implementation of the Act. The scope is very wide. It amends the preamble to the Act, it inserts definitions, revises the property categorization framework, allows valuation exemptions, and is designed to clarify matters and avoid misinterpretation. As amended, the Act will make it clear that rates are not linked to the provision of services or to the erection of infrastructure. Rates are a tax. If your infrastructure is not there or your services aren't there, you're going to quite clearly not be in a position to refuse to pay your rates. It's going to allow not only for the increase but also for the decrease of rates. It will allow for differential rates on parts of a property. For example, if you've got a farm, part of which is used for accommodation, they'll be able to rate the accommodation segment on a commercial basis whilst reducing the rates on the farming area. For different rates on residential property not used for the permitted purpose or not used for any purpose. And the most important thing, and what this video tutorial is actually focused on, is a definition of residential as excluding properties that accommodate anyone other than the owner. Now, the apparent consequence of this amendment would be that the definition of residential property would be changed. Only the home that the owner is actually living in would be considered residential for rates purposes. People who own residential property as investments would, it seems, pay much higher rates, perhaps double, and the letting operation would become less profitable. So this is the question: will landlords actually pay commercial rates on residential properties? And to what extent have these concerns been addressed? Well, as far as I'm concerned, the big picture here is that the government depends very heavily on the private sector to capitalize new private developments. Both developers, banks, everybody, they expect investors to come along and snap up a substantial portion. It is estimated that perhaps 30 to 40% of all current sectional title schemes in South Africa are owned by investors. That may bring its own problems, but the money at least is in those things, and that means we're getting housing. Reducing the return on property investments would drive money out of the sector and into other types of investments. It would reduce the number of new housing developments and slow down the drive to house all South Africans. So is this a real danger? Well, the Deputy Minister says it's not. He says there's no intention to make landlords pay commercial rates. He says this is aimed at B&Bs and similar commercial uses of residential properties that should pay higher rates, not aimed at all tenanted properties. And he says some people seem to think that there's a problem with the wording, but we don't think so. And it's in that we don't think so that I think the danger lies. Because lawyers say the wording of the provision clearly does affect all rental property rented out, or property rented out. There is no obvious intention to exclude properties other than B&Bs and similar commercial operations. As the wording now is, it is argued, hit investment properties leased out for long periods as well as short-term letting operations. So what can you do if you think that anything needs to be done? There are some people who look at this and say, great, the fewer people we have leasing and sectional title, the fewer problems we'll have with behavior, people will pay their levies on time, oh, it'll be wonderful. But not everybody thinks that. I certainly don't think that. So what can you do? If you think this is a bad thing, you've got a short period in which to object. The deadline for objections is the 22nd of July. You have to object by email, and I've given you the email address. Give your name, Give some short detail of who you are. Clearly say what you don't like about this, what you think it's going to do that's not good. Give your reasons, in other words. This should be changed because you tell your story. And if you put that in, then you'll have some influence on the outcome of this particular proposed legislation. Thank you very much for joining me in this Paddocks Club tutorial, and I look forward to chatting to you in the discussion forum.